We have Justice Sanjay Kishan Kaul, who is very respectable judge from Supreme Court, recently retired. Sir, thank you very much for joining NDTV.
Thank you.
We have seen you for many years as a judge in Supreme Court as well as in High Court. You are called like a bold and smiling judge. How you control your anger and anything, because you heard many serious and sensitive cases.
So I think anger control is something which our even Shastras talk about. It is a bane if you tend to get anger. I sometimes even advise my children that if you are angry, don't react. Count till 10. Let it die down. Otherwise, what is said, the Shabdaban, can be very damaging also. And I believe the court atmosphere must be kept on the slightly lighter plane. It's a serious job to decide and to argue. So humor should form a part of the court system. That's something to be, I think, greatly learned from the British system, which has humor as an intrinsic part of it. And it's the two lawyers set the work and argue, and it's our job to decide. So that's my general belief.
Yeah. Sir, you have been part of many historic judgments like same-sex marriage, 370, Article 370. As a judge, how you see 370 judgment?
I believe that if 5 judges of the court have taken a unanimous view, at least the opinion of these 5 judges is that what was done was correct in accordance with law. There are 2 aspects of 370. One is the abolition and the second is the process. The debate has been more over process, I would say. On the first part, though there would be a contrary view, the very assimilation of Jammu and Kashmir state into India was carried out with a slightly different process. You had a concept of a state constituent assembly which came up with a state constitution. But orders passed from time to time transferred the powers to the center. Something was still left, maybe a shell was left. Whether that shell should have remained with that little bit or should go is a political decision. The parliament passed, reflecting the political decision, passed that law. And what was tested before us was, firstly, whether really was it a temporary provision. All 5 held that it is a temporary provision by the very incorporation in which it is made, under the chapter in which it is made. Now the decision has been taken that a full assimilation must take place. Whatever remains of that must go, and that's what is the correct legal position. Second was the process. So there has been some that there was no elected state assembly at that stage of time, or how it was gone about it. But the court will determine on the given ground reality. The given ground reality was that at that time there was no state assembly. It was dissolved. There was no government in operation. The power vested with the center. And therefore 5 judges in their wisdom came to the conclusion that the process was also correct. People are entitled to a different opinion if they so want.
Yeah. Sir, you have raised the pain of Kashmiri Pandits also in your judgment. What was going on in your mind that time while writing this judgment?
So, one is the legal principle. One tackles it legally. All 5 of us did it in a legal way. There may be some divergence of view which I have taken on the whether any sovereignty existed, what time it was extinguished, but that's a matter of process and time. The second part was out of some experience of mine, which is that there should be an end to this conflict. It's a social aspect also. How to bring an end to the conflict. We saw 1947 as a partition, which so many people suffered. It took a generation to relive it and start their lives. They started, went ahead, the next generations may have forgotten. They have known about it as history. But they know what has happened. Yet they proceed further. Similarly in Kashmir, 4.5 lakhs people were compelled to migrate. Their story was never fully told, nor remedy given. Army was brought into force because it was a warlike situation. Army has its own ways of operation, logically so. And in the whole process of controlling law and order, excesses may have occurred on the people who were living there also. So you have 2 sets of aggrieved people. And that's why I have talked about state and non-state action in which people have suffered. But if we have to proceed further, and I believe are proceeding further, then to put a quietus to the issue, it is necessary to at least acknowledge there is something wrong. So the person or whose family has suffered must feel that, look, our pain may be 30 years old, but somebody recognizes that we went through this pain. Or if it has happened in 1990s of the people who remained there, they must also feel that what went wrong in this process of controlling law and order should be recognized and our pain should be accepted and recognized. That's the philosophy behind the South African module, which was not based on punishment basis, but or a retribution basis, but was based on an acknowledgement of the wrongs which had happened, and in a way a system of apology for what had happened.
Sir, you are from Kashmir itself. So what was your experience before this all things happened?
So people have lived in a very assimilated manner for years together. It's a very peaceful society. At time of independence, even Gandhiji said that it's a promise of hope how Kashmir is. But I believe that from 1980s onwards, something was going wrong. Maybe it was not anticipated, maybe at ground level it was not felt. And then the situation started getting a little more worse post 1987 elections. And it exploded in 1989. So from a place where people were staying in assimilation to such kind of divide, maybe something was not anticipated. Some misjudgment calls occurred. But having taken place, the very sovereignty of the area was in question. And therefore very harsher steps became necessary, including calling in the army and the paramilitary forces. There were resistance, so some things have happened, and before that the en masse migration which had taken place. So that's what I said, that nobody has been able to yet pinpoint why it occurred, why something should have occurred differently. And it is time to look into it, acknowledge it, so that such incidents don't arise in the future and we move forward from where we were.
And you gave order also for election in up to till 30th September 2014. Hope Kashmir will be back on his track. Sir, this 370, whole world, people from anywhere in the country or outside, they watched the proceeding of 370, hearing and then judgment. How you see technology is being used in Supreme Court, live streaming is being done, and transcribing these, translating these judgments in regional languages. How you see this?
So initially when debates about use of technology to transmit the court proceedings were there, I did have some apprehensions personally that it should not become another method of trying to play to the galleries by the legal fraternity. But COVID forced this on us, and people learned, judges and bar both learned to operate it. Our technological skills improved, and it derived immense benefits, I think. One of the major benefits is access to justice. Yes. People who are in farther off places, to whom it was expensive to come to Delhi and take up Supreme Court proceedings, started doing it from their respective home states. The local lawyer would operate. So I saw from Chennai, a number of Chennai lawyers where I had been Chief Justice argue the matters. The dismissal rate of fresh matters is well over 80%. So they would know if it's worth going further or not. Now that's one aspect of it. Gender benefit is another example of it, because the challenges which women face, especially with children. So that helps them. A place like Delhi has many tribunals, so accessing it from a central point, how to reach different processes in the traffic position which is in Delhi. So this provides a better access. I think the hybrid system has come to stay, and in fact must be fully institutionalized, so that every court operates on a hybrid system, leaving it to the lawyer or his best call to appear from wherever he wants or to come to court. Now this wherever he wants, some formalities some courts expect. Don't sit in the car and start arguing and then it gets disconnected. You must be in some place from where you can access the court proceedings properly. Now that being the position, beyond that, to live telecast some of the constitutional matters, the public is watching. So there was a public curiosity how courts operate. I know a lot of even my relatives who would go and see those proceedings this way. So the public curiosity is in a way satisfied. Apart from satisfaction of the curiosity, some of them who are interested in subjects join the proceedings. That's also been a healthy system. Translation into different languages or on the movement transcriptions are again issues of technological assistance which take place, and especially in big and bulky matters, operating virtually has a great benefit because you don't have to deal with physical files when there may be 20 volumes or 30 volumes. So it's worked extremely well. I think it's something for the future.
And sir, we'll talk about collegium system. You have been part of collegium since a long time. What is your opinion on collegium system?
So there was a particular process from 1950 to 1990. It operated. Every system will have a little bit of its own problems. The judiciary in its wisdom thought collegium system was a better system from 1990s onwards. And it worked well for a long period of time. There were possibly, one reason was there were coalition governments. So the pressures on the judiciary in this aspect were less and it was acceptable. Once a single government came, law was changed because the political class as a whole, irrespective of opposition or the main, felt that there must be a greater say. It should not be left totally to the judiciary. So they brought the NJEC in their wisdom, and there was prior discussion on this, formulations on it. Some changes were made, and that became a subject matter of challenge and was quashed. Now, one of the main reasons of challenge was that the basic structure is affected, the predominance of the judiciary is affected because in a 6-member committee, 3 members of the judiciary also could be completely blocked by the other 3 members because it only envisaged a decision with a majority. Therefore, I have observed that maybe a system where we could have tweaked it by giving a casting vote to the Chief Justice, or at least made sure after it is cleared by NJC the appointments take place, could have met the system. I am conscious I am speaking in retrospect, but we have seen the problems which arise in the current system also. This tussle which has arisen is on account of the government wanting to play a bigger role and the collegium system not providing that much role. It has a role because government's opinion is taken into account. It's not that it's not taken into account. And even in the collegium system, from the names which come from the High Court, by the time they get through the collegium, they're not even 50% of the names which get through. So there is a serious process which goes through. Now, therefore, there has to be a dialogue. To do the dialogue, if it's across the table, I think it's better. So institutional dialogue would be better rather than any endeavor at a backroom dialogue. Because ultimately, this issue has to be addressed. The names can't keep going up and down. Collegium system talks about right of government to object once. But if the government doesn't object or doesn't appoint, the names keep pending. 13 names like this are pending. Or if they are reiterated, the government has to appoint, there are 4 names pending like this. So on these names, there is a deadlock. Apart from this, when we effected transfers, 6 transfers are still not been implemented. That's another area. 3 Chief Justices recommended. The recommendations have not seen the light of the day. And there are, of course, now more Chief Justices vacancies. So we have about 8 Chief Justices not being there, which in turn affects the appointment processes if the permanent Chief Justices are not there. So any system should work well. And it would be shutting our eyes if we say, no, there are no problems with the collegium system. Either we work it as the system exists now properly, we can't say that the government doesn't like this law so it will not implement it. Or we come up with something better which is perceived, which satisfies the test of law or in constitutional scheme.
Sir, what is your message to the younger generation who wanted to be in law field or they are working in law field?
So this is a field where sky is the limit. You must work hard and enjoy what you are doing. That's essential of this field and any field. If you are committed to, it will work out well. Yes, if you are in litigation, the initial years are very challenging. But earlier it was even more challenging because a senior would consider it a privilege even to give you a placement in the chamber. Today people talk about a stipend at the threshold itself. Law firms have come up. So some sustenance model must be there. But litigation itself is a field which takes time to settle down. And once you settle down, it compensates disproportionately later on. If you make, I think compromises is what I will call it initially, it doesn't stand you in good stead later on. So it's necessary to go through that grind initially to be able to do this. Of course, there are many other options open after law. Teaching, earlier people were not going. It's far more financially lucrative. So there are people I know who are academically interested to go into it. Corporate side, many other institutions have it. So the field is quite wide open, and national law schools have played a very important role in this. I think they must see the examples of the first generation lawyers who have done extremely well, which itself should be an incentive for the younger generation as models to do that quantum of work, watch how they perform, and be positive about their future.
Thank you very much, Justice Sanjay Kishan Kaul in New Delhi with camera person Sachin Gupta and Momin Ashish Bhargav for NDTV.